Here's an analogy of traveling with dope in your automobile to traveling with an illegal firearm in your automobile. If you are carrying a gun in your automobile while driving, are you prosecutable if that gun is actually taken apart and now you are traveling with the materials of a gun that cannot be defined as traveling or being in possession of a firearm? Can you be defined as being in possession of a firearm with only the materials that make up a firearm that are not constructed to completely define the firearm for what it is? Are you really illegal? Did you really break the law? Are you breaking the law? Nah, you're really not. So, to carry the materials of a gun is not the same as being in possession of a gun. Because one, if you are not a gun expert, you have no awareness of a gun, you have no information of a gun, you have no education of a gun, how would you know what gun materials look like? If you do not know how to take apart a gun or to put a gun together, how would you know what those materials are? How could you be proven to be in possession of an illegal firearm? That's not definitively what a firearm is, only what a firearm could be if the materials were assembled. How would a prosecutor prove that the traveler driving the automobile is consciously aware of this, or is obligated to be consciously aware of what these materials are, seeing as he does not have the expertise to even assemble the materials, let alone define what they are? This is the same as dope. If you're traveling in an automobile with some dope in your car, it's left in a prosecutor's effort. It's the prosecutor's effort to prove that the driver was in possession of this dope. How can a prosecutor prosecute a traveler driving an automobile of being in possession of an illegal controlled substance if that person was unconscious of that substance within the vehicle, the automobile? Two antonyms of one another. This is the same because how could you be in possession of a substance or any material item or any ingredients that you're unconscious of? How can you claim possession or ownership of a substance or any material item or ingredient that you are unconscious of? In synonymous context, that you are unaware of, that you are uncognitive of. There's simply no way to prove that they are in possession of that illegal substance, only that the substance was inside of the automobile. So now, is it deductively correct to define someone as illegal, prosecute them and convict them for being unconscious of what's in their vicinity when there is no law that states you must check what's in the vicinity of the automobile before we travel the automobile? There's no law that states that the driver is obligated by law to inspect every inch of the automobile before he travels an automobile. So how could that driver be in possession of a substance he is unconscious of? How would that driver, that traveler, be defined as guilty? How? Explain. So, with the second episode of Catch 22's analogy, the point being is, you can't prosecute someone for having the materials of a gun in their car if they are unaware what those materials are, because it's always going to be a possessions charge. The same goes for dope. If you're unaware that you have dope in your car, well, how can I be in possession of something that I am unaware of? The ball is left in the court of the prosecutor to prove that the defendant was actually conscious, cognitive, and well aware that these materials was inside of the car. At that point, it's left to the prosecutor to actually become the fucking psychologist. It's up to the prosecutor to become the mind reader. Now, prosecutors are prosecutors. They're not psychologists. Judges are judges. They're not psychologists. The point that I'm concluding with everything that I've said thus far is that there needs to be a how to define someone as guilty. Who, what, when, where, how. If you don't have the how, the case is getting thrown out. Who, what, when, where, why. How. If you don't have the how, the case is getting thrown out. If you lie about the how, you just lie about, blatantly, you lie about the how, the lie is going to get resurfaced during the court procedure. It's going to come to the light. There's no way to lie about the how, because the how is the sound logic. And if you don't have sound logic in the courtroom, then you're left with an emotional belief, which has to be fundamentally substantial enough to prove factual. Because if your substantial belief is not proven factual, then it is not true. Because any truth requires facts, and any fact is true. If it's not a fact, then it is not true. If it is not true, if that is not true, then it is not a fact. So all proofs must be truthful, with no room for improvement besides empirical truth and facts. Only the facts can prove the truth. Beliefs, on the other hand, beliefs are inefficient. Beliefs are unsubstantial. Beliefs are not facts. A belief cannot be a fact, because if a belief was a fact, it wouldn't be a belief. It would be a knowing of a truth that was proved as a fact. This is Analogies of Catch 22. If you want more, let me know. I'm the best lawyer that I know, to be honest. I didn't have to go to law school. I didn't have to read a bunch of law books. But I am native Cherokee Indigenous tribe. I do specialize in legalese. I've been speaking this language, I don't know, in vibrations for eons. So, law library is fluid, to me at least. If you need help with law, holla at your boy.